And gentlemen, boys and girls, and one cat in Connecticut, we welcome you to this feature talk, Tools and Strategies to Avoid Estate Planning Tragedies. I am the spokesman for the webinar network, and let me tell you that we are really scraping the bottom of the barrel today to get this guy to finally show up on a Saturday, and hopefully you'll understand what he's talking about. His feeble attempts at humor are not as good as the content, which isn't so good either. In any event, without undue delay and with a cadence that we hope you will understand, here is the star of our show, the mediocre and somewhat boring Alan Gassman. Where are you? Alan, you here? It is 11 o'clock on Saturday. I hope you enjoyed the early bird special. We're here to talk about tools and strategies to avoid estate planning tragedies. And if you have questions, please send them to us. If I cannot answer the questions during the presentation, I will make sure that I answer them afterwards. We are scheduled to go 60 minutes here, which is about 1.3 billable hours for many of you. And I will try to finish on time. If I don't, if you're done before I am, I understand. That's the way it goes. By the way, we have been giving this Saturday presentation for quite a few Saturdays, actually months of them. And this is the first one that we are also receiving an audience from the CPA Academy, my friends at cpaacademy.org. So if you signed up for this webinar through CPA Academy and you want to get CPE credit, then you had to go ahead and log in through their invitation. So if you got an invitation from me and an invitation from them, and you want CPE credit as a CPA, if you logged in and it looked like this, then you're not going to get CPE credit. Immediately log out and do something better with your life, or log out and go ahead and click the login to webinar from the CPA prompt. So I apologize for any confusion or inconvenience which will occur throughout this presentation. If you did not come in through cpaacademy.org, then you don't get continuing education credit because it's not a very good presentation. That is the main reason. Now, within 3 to 5 hours after the webinar, at least the non-CPA Academy registrants will receive a follow-up email, and you'll be able to click in order to watch today's recording as many times as you like, whether you want to or not. And if you have a cat, we are hearing all over the place that cats are really enjoying these presentations, especially the charts. So if you have a question, you can email me at agassman@gassmanpa.com, or you can click where you see the red arrow there and type in your question. And of course, always begin your question with, "I so thoroughly enjoyed your presentation and had a question." That's a great way to ask a question. Or, "Your presentation was very mediocre and I have a question." So we're going to keep this series going. Next Saturday, we're going to talk about creditor protection in estate planning and how they interact and how to integrate creditor protection into estate planning. And then on the 28th, by popular demand of 3 or 4 people, the mathematics of estate tax planning. I'll just update it a little bit, talk about some recent developments, and we'll also cover Pythagorean's theorem. My friend Andy Soon and I will be talking about estate planning for Korean American families, May 25th, 2022. That's going to be very interesting. We're going to talk later on another presentation about handling assets that are in Korea. So please join us for that. So enough of the same shameless self-promotion. Other to mention that you may have noticed that our Thursday report came out on Thursday, which it commonly does. And we've got some pretty good articles on the IRS clawback regulation and on the IRA pension rules. We're boiling them down. The concept of having your IRA or pension payable to a trust as we become more familiar with them. So if you're not getting the Thursday report, it's free and it's absolutely worth every penny of that. And you could just email me and I'll be glad to put you on the subscription. The clawback rule, what is the clawback rule? Today, I have a $12,060,000 exemption, and I give my beloved family a promissory note for $12 million. It's legally enforceable under state law because my family does something in exchange for it. Maybe they agree that they'll read the book Catch-22 by Joseph Heller within 6 months, and that causes the agreement to be legally binding. And then I file a gift tax return and I show a $12 million use of my exemption. All right. Then in 2026, the exemption goes down to, let's say, an inflation adjusted $7 million. And then what's even worse than that is I die in 2027. And my estate consists almost entirely of $13 million worth of assets, but I owe a $12 million note, so my net worth is only $1 million. So there's no estate tax because $1 million is less than $7 million, at least the way I do math. So is that right or wrong? And the answer is, under the new proposed IRS clawback regulations, if you have done this, the IRS will consider your exemption amount to be based upon the exemption when you die, not the exemption when you made the gift. They'll bring the assets back into your estate at the 13 million. And in my example, they'll reduce that by the 7 million and they'll charge you estate tax on the difference of 6 million. So these clawback regulations, which are going to be valid, they are pursuant to an IRS statute which says that the IRS has the right and the power to put in reasonable clawback regulations. On that one, they're probably going to win. So one thing you could do if you're really, really aggressive is to maybe set up an LLC and then have the LLC provide the note to the family. So then you don't owe the note to the family, but that may be very aggressive. So there's going to be other things to do, but the clawback regulations are going to get ugly for people who gave away promissory notes unless you fully get out of this promissory note more than 180 days before death. The other example of the clawback regulation is that if I give you a ranch and it's worth $10 million, and on that ranch are 400 cows, and we agree that I'll give you this ranch as long as I can keep one cow on the ranch and visit it every other Friday. So I keep one cow on the ranch, I visit it maybe a couple Fridays, but I keep the cow on the ranch, and the cow gets to eat the grass, gets to enjoy the scenery, gets to hang out with the other cows. So then I die, and I die after the exemption goes down by half. So what happens is, under Internal Revenue Code section 2036A, it says if you give something away, but you retain the right to have use or benefit or income from what you gave away, then that asset is still in your estate. So the cows in my estate, I mean, that's holy cow, that's no surprise, but the whole ranch is in my estate. But here's what makes it worse. Under the clawback regulations, the fact that my exemption was 12 million when I gave you the ranch, and I thought I used 10 million of the 12. Well, now the ranch is in my estate, so the exemption is 7 million now because I die after the exemption goes down. So I'm going to pay a estate tax based on that $3 million difference. And that will cause use of my entire exemption, so all my other assets will be subject to estate tax. So when the IRS comes gunning under 2036, whether it's A1, which I just described, or A2, which has nothing to do with steak sauce, then they're going to be going for double jeopardy. They're going to be looking for a lot of extra money if the exemption goes down. So those would be reasons to read our article on the clawback, whether you like cats or not, or tigers or lions or steak sauce. I would definitely recommend that first article, even though Brandon did most of the work on it. For those of you who are new to this series, you have my apology for the mediocrity of it, but we offer you some spreadsheets. And for those of you who have already seen the spreadsheets, some of you like looking at it anyway, but one of the spreadsheets here that we provide at no charge is Hubert chart. So one of the mistakes that we're commonly seeing when people come to us from having done estate planning wherever they did it, and this is really showing now, is that they haven't used the CPA. And the CPA is a qualified personal residence trust. It's right in the Internal Revenue Code under section 2702. So I've got two code sections for you to read tonight, 2036 and 2702. And 2702 says that if you have a home and you place it in a qualified personal residence trust and you retain the right to use the home for a term of years, then your gift of the home to the trust is discounted. So in my example here, a home worth $1.9 million growing at 3% a year is put into the CPA by a married couple. They're 74 and 75 years old, and the gift that's been made to this CPA, even though it's a $1.9 million house they're getting out of their estate, the gift is only $961,000. So I've got a $1.9 million house, and if they both live the 8 years, and this is really two separate CPAs for two separate people, which is, you can ask your tax advisor for more information on that. But this is getting a $1.9 million house out of your estate using only $961,000 of your exemption. But it's better than that, because see, if the house grows at 3% a year here, then after the 8th year, you have a $2.4 million home, and it's out of your estate for estate tax purposes, and you only used $961,000 of the exemption. But then the client says, what happens after the 9th year? What if I'm still want to live in the house? And then the answer is really good. Well, that's fine. You can continue to live in the house, but you'll have to pay rent. And that's really good news, because it's going to get your estate even lower. So if we assume that rent is going to be paid at 8% a year, then 8% of the value of the home, you see in year 9, they're going to pay $192,000 in rent, and then the following year, $198,000 in rent, et cetera, et cetera. So the economic result here is, for, let's say, year 15, the house is worth $2,873,000. The total rent paid and reinvested at 7% is $1.5 million. So you've got a total of $4,452,000 passing outside of the estate, and you've only used $961,000 of the exemption. So you've saved at a 40% estate tax rate $1,400,000 in estate tax, and you've locked down the house. Now, I like the fact that you've locked down the house because a lot of times the couple has an emotional attachment to the house, and they want it to go to the children. They don't want to go to the next spouse who they haven't even met yet. So the analysis, comes out pretty good. Now, what does this do on the income tax side? On the income tax side, and it's a mistake not to at least think about the income tax side, you may be paying more capital gains tax when the home is eventually sold. Now, right now, the capital gains tax, federal and Medicare tax together on the sale of a home, there's no tax on the first $250,000 if it's sold by the surviving spouse. And then you're in the 20% capital gains tax rate at the highest rate. And then if you have more than 200,000 of income, you're at the 3.8% Medicare tax rate. So what does that do? Let's say in year 15, the home is sold for $2,873,000. And let's say it has a tax basis of $1,600,000. That's what the home cost. So the capital gains tax would be $351,000 if we assume if we assume 28.8%. But then if we saved $1 million in estate tax, we're still way ahead. Now, as of today, if I do a CUPERT and I die during the term, I get the stepped up basis. If I die after the term, you may still get the stepped up basis if the CUPERT is drafted properly. And we'll talk a little bit more about stepped up basis in a little while. But here's what I like about the spreadsheet is the buttons, because I love buttons and I shouldn't be allowed to touch them. But the only thing on this spreadsheet that you need to get from Tiger Tables or Number Cruncher or another one of those professional software programs is the exemption use amount, which will vary based upon the age of the client and the amount and the value of the house. Other than that, though, this spreadsheet, if I want to increase the home value, all I do is click up for the home value increase. If I want to increase the use of the exemption from Tiger Tables, I just increase it. If I want to increase the percentage of value that I'm using for my rent calculation, I can click there. If I want to increase the percentage of annual growth of the home, I can click there. So that's just what my office calls Allen proof, because I'm so bad with spreadsheets. All I know is how to tell people to do them. And then, of course, the length of the CUPERT. And you would think that the longer the CUPERT, the better the savings, because you have more of a discount. But remember, because you're able to pay rent, sometimes the shorter the CUPERT, the better, and then you don't have to worry so much about the client dying during the CUPERT term. So when we have clients that come and they've had their estate planning done in the last 3 to 5 years, and we say, how long do you plan to live in your house? Forever. Or if I don't live in it forever, I'll certainly sell the house and buy another house at least as nice. Well, then why don't you have a CUPERT? Well, because it really wasn't mentioned to me. So I think that one mistake is not at least thinking about the CUPERT. And then some clients come to us and say, yes, I have a CUPERT. In fact, I love my CUPERT. I wish I could do something for my vacation homes. And the answer is everyone can do 2 CUPERTs. So it's just like going on Noah's Ark. So my wife and I could do 1 CUPERT with our homestead, and then I could do 1 CUPERT with our first vacation home, and then she could do a CUPERT with her vacation home. And then another mistake that we commonly see is we see reciprocal CUPERTs. So I do a CUPERT for Marcia and our descendants, and the house will be out of my estate and it'll never be in her estate. She can be the trustee. She can use the house for health, education, and maintenance, which means she'll never have to pay rent. So that's all great. But then if she does a CUPERT for me, that's reciprocal, it's opposite, then the IRS is going to say, wait a minute, this is just like Alan did a Cupert for himself and Marcia did a Cupert for herself. And then under 2036A, if I do a Cupert for myself, it's going to be in my estate, and then the clawback rule is going to apply. So I'm going to do a Cupert for Marcia, and then she's going to do a Cupert for the children. So if I don't behave, I will be out in the cold and paying full rent. But if I die first, she'll only have to pay rent to her Cupert, not to my Cupert. And the advantage of us doing two Cuperts, the first advantage is our legal fees will be higher, and that's what we're all after. But the second advantage is if we have a $2 million home, then my half of the home is not worth $1 million. Now, my half of the home, by the way, is my office and the backyard. Marcia's half of the home is the rest of the house. But half of a home, also known as a 50% undivided interest, is not worth $1 million. You could take about a 15 to 20% discount. So now I'm really I'm reporting this gift at $850. She's reporting her gift at $850. The appraisal shows, well, the house is worth $2, 50% is $1, but because of discounts, it's $850. So not doing that would be another tragic mistake, staying on our tragic error theme today. Maybe it would be a tragic error to continue to watch this webinar. Let me race forward and do our first polling question. Let me see where it is. It is on page 32. Okay, so for those of you who are CPAs on cpaacademy.com, you have to concentrate very carefully and type in either A, B, C, or D. Those are all letters in the alphabet. And we're going to time this 1 minute. And if you type in A, then you will get the national bestseller book, 8 Steps to a Successful Estate Plan, whether you want it or not. And if you type in B, you will get the Florida Physician's Guide to Creditor Protection. And if you type in C, you'll type Grow Your Medical Practice, which was written by David Finkel, who is a well-known business coach and leading thinker, and Prikasit Singh, who is one of the smartest people that I know. And then if you press D, you'll get the book, What Estate Planners Need to Know About Bankruptcy. So for those of you who are not in the CPA Academy, you still get one of these books. We'll be sending you a PDF. All you have to do is press in A, B, C, or D. And a minute is up. We hope you enjoyed our first polling question. By the way, Matt Polling in Tampa is a really good real estate lawyer. Okay, here's another error and tragedy in estate planning, and that is, does the client set goals and even know what we're trying to achieve? Now, I'm not talking about the drive-by will where they call you at 8 in the morning and say, well, can I run by the office and sign a will because I've got a flight this afternoon? That probably is not going to achieve as many goals. But the first goal, quite frankly, is, do these people even know what they have? And the answer is usually, eventually they will, but they're not really sure now, and certainly they don't know exactly how it's owned. Number 2, are they protected from creditors? So they normally are more worried about, where's this going to go when I die, and am I going to pay taxes? But then they're just assuming that we're going to also protect them from creditors, whether we do or not. So we want to make sure that that is addressed. Third is estate tax protection. And the biggest tragedy on estate tax protection that we see is that planners do some things to avoid estate tax, but not everything possible. So Sure, you take a $30 million family and reduce their estate to 25 million. That's great. But what about that other 4 or 5 million? And what about the future growth? So that can be important. Number 4 is, are you protecting the estate from the next spouse? So you really have to think about that with a married couple, because most of us design our estate plans where after the first death, there's a lot of assets owned by the surviving spouse. And when they sign their documents, if you say, now you realize that after one of you dies, a lot of it's going to be in the surviving spouse's name, and it may go to the next family. And they look at you and say, what? That's not what we intended. So that may entail a joint exempt step-up trust called a JEST trust, which would be a joint trust that would lock everything up on the first death so that the surviving spouse has to pass it to the common descendants or use it reasonably. And that JEST trust could give the assets in the trust a new income tax basis on the first death to fair market value, so that that first death would not be quite as upsetting. Those are things that people just don't think about. Planners have the tool in the toolbox, but it's just not thought about. And when you're representing somebody who may get sued, and a lot of people these days may get sued, then if my spouse dies and I'm required to put my remaining assets into an asset protection trust by contract signed by my wife, with my wife, and she will haunt me if I don't, and my children will sue me if I don't, then that's going to be an asset protection move that is made not for the purpose of avoiding an expected creditor, but for the purpose of complying with a contract. And then number 5, another error we commonly see is, oh, and when we both die, everything will go to our children, and when they're 35, they'll get it because they'll just be lovely, responsible, they'll never be sued, they'll never go through divorce, they'll never drink too much or gamble too much, and they'll always invest wisely. And the dish ran away with the spoon and pigs fly. So in the real world, we want to leave assets in trusts that will not ruin children's lives or allow the assets to be taken away. So plan A, outright to the child. Goodbye, assets. Plan B, to the child as trustee of a trust. The child can receive whatever he or she needs for health, education, maintenance, and support. The child can appoint the assets to his or her descendants, and the child could even appoint a best friend to become special trustee who could give the assets to the child. Under that scenario, the child's creditors can't reach the trust, the child's spouse can't reach the trust on divorce, the trust is not subject to estate tax when the child dies, even though the child could get it all out by appointing their best friend as a temporary trustee. So that's pretty good. But the risk of that situation is, what if the child marries somebody who's overbearing? Or what if the child breaks their hip at age 85 and there's an aggressive nurse and a lot of pain pills involved? What if the child has a next door neighbor who knows all about investments and how to lose them? So how about if this child has to serve as co-trustee with his or her choice of any licensed trust company in the United States of America? The child can shop for the lowest cost trust company, or maybe has to serve with the family lawyer or the family CPA, but cannot serve alone. So not going to be subject to undue influence, we hope, not going to be lost to because the child borrows it out or does something silly with it. So those are door number 1, door number 2, and door number 3. Or you could also have the child select the box where Carol Merrill is now standing. If you like the TV show, Let's Make a Deal, Jimmy Buffett has a great song about that show from the A1A album. And I think the name of the song is My Whole World Lies Waiting Behind Door Number 3. A very good one. Okay, so next mistake, tragic mistake, is the process or the lack of the process. Because the client typically doesn't understand what it takes to do a thorough and thoughtful estate plan. So let's just say that it can be a lot of work to do a thorough and thoughtful estate plan. And a lot of law firms, bless them, say, oh, estate plan, $2,500. Come on in, we'll get it done. And we'll do a lot of stuff that's really important. But for $2,500, we can't read all your operating agreements. We can't check and make sure your tax return is consistent with your deeds. We can't spend the time it might take to develop a special trust for a special needs child. But come on in and we'll do some nice planning for you. And a lot of clients have that attitude too. They call and they go, I'd love you to do my estate planning, but I have two questions. The first question is, what will it cost? And the second question is, what will it cost? And the answer is, it will cost $2,500, but it won't be very good. So that whole process of gathering the information, understanding what's going on, and then working with the team of advisors. It would be a mistake not to work carefully with a team of advisors. It's not just the lawyer. And by the way, you don't need a lawyer to do your estate plan. You could go to a company that is engaged illegally in the unauthorized practice of law, and they can do your estate planning for you. And I've seen some of their programs, and they're really great advertisements, and they have some really great ideas, and their documents can be very good, but they're always done wrong, or at least the ones I've looked at, they're always done wrong. So yeah, I could probably perform my own appendectomy as well, but I don't know that I would definitely get the appendix. I might actually take out a kidney, who knows what. So we suggest a licensed attorney. And then I think your accountant needs to be involved, because your accountant knows what's going on and has some tax expertise and will have to do the tax returns when this is done. And then your investment advisors, a lot of investment advisors have really good input in an estate plan. And then there's the life insurance agents. And then you may want to use somebody who has special education, like a certified financial planner. And then you might want to hire a psychic to see what's going on. And then you might want to bring your psychiatrist, because you may need to change your medication after we have these discussions. Your family members may be involved, your banker, then there's your cat and your cat's psychiatrist, and then many more lawyers. So we want to involve the right people at the right times when we do this. Go to the next polling question now on page 39. And by the way, we'll be doing a part 2 of this presentation where I'll be able to handle some of the other slides. So here's the polling question. Thank you, Matt, for all your help in the real estate area. All right. Which of the following is true? A SLAT is a spousal limited access trust, not to be confused with a spousal limited unitrust, which is known as a SLUT. So that's A, SLAT, spousal limited access trust. You can put assets in the trust. One spouse puts assets in the trust. It's for the health, education, maintenance, and support of the other spouse, and it's not subject to estate tax when that beneficiary spouse dies. Okay, B, a SLAT is a defective grantor trust if the beneficiary spouse is the trustee. A defective grantor trust is a trust that is disregarded for income tax purposes. So I set up a trust for Marcia's health, education, and maintenance. Marcia is the trustee, and all the income and deductions from that trust go on my personal return, and we call that defective. So that is B. C, the only way to get out of making that trust defective is to provide in the trust agreement that another beneficiary of the trust would have to approve any distribution to the spouse. So that is called an adverse party provision. And if I set up a trust for Marcia, and it says that in order for Marcia to get a payment, it has to be approved by one of our descendants who is an adult beneficiary, then it may be possible to what we call toggle off grantor trust status, so the trust would pay its own income tax in the future. The law is not perfectly clear on that because of something called the repeal of Code Section 682, but you definitely would want an adverse party clause in case you would want to toggle off grantor trust status of your SLAT. And D is all of the above, which is the correct answer. So I'll give you a few seconds here. I know all of you who are not CPAs understand this and already put D from the very beginning, but the CPAs are a little bit more methodical. They think it through. So D is the correct answer. And we will now go to more checklist items. So on page 26, did you set a goal and did you get the estate plan done? If it was done on a budget, or if it was done by a lawyer or with professionals who are not fully versatile, or who told you that you would have to pay some estate tax anyway, then maybe you check again. I was taught early on in my career that the estate tax is a voluntary tax, and if you do everything possible to avoid it, you can avoid it, although that may involve some charitable giving, but maybe charity won't get as much as Uncle Sam would get, and your family gets left with more. So that brings us to number 6 here on page 27. A big mistake we do commonly see is families with high net worths, 50 million and more, don't really understand, and their advisors do not completely understand how you would use a charitable lead annuity trust or an administrative note, a charitable foundation, to avoid estate tax, avoid income tax on IRA payments, and still significantly benefit family members. The Congress has done a fairly good job in having tax legislation that says, hey, if you take care of charitable purposes, we will reduce your income tax and your estate tax obligations. So that is something to just keep in mind if you're an advisor, and take a second pass at what's going on. Now, a lot of estate taxable clients have multiple entities, and we want to be very careful from a creditor and an estate tax standpoint. And one example of that, and a terrorist situation we see, is I put assets in an LLC, and I am the 1% voting member and the 99% non-voting member, so I own 100% of the LLC, and then I give 99% of it to a trust for my children, and I keep 1%, and I have a duty to vote my 1% responsibly, and I can only get 1% of any distributions from the LLC, and that is how most of these are done. And when I die, I expect that 99% non-voting member interest to be out of my estate. So I put $10 million of stocks into an LLC. I give the 99% non-voting member interest away more than 30 days after funding of the LLC to avoid the step transaction doctrine, which is another common mistake. So you fund the LLC, then you wait a while, then you sprinkle the pixie dust, and then you transfer by sale or by gift that 99% non-voting member interest. And then you wonder whether Internal Revenue Code section 2036A2 may apply, which says if you give something away, but you retain the right to control its enjoyment in conjunction with one or more people. So the IRS, notwithstanding that there's a US Supreme Court case in a decision called Bosch, B-O-S-C-H, where Mr. Bosch had voting stock in a company, and his family and other investors had non-voting stock, and the IRS said 2036A2 causes the family's interest in this LLC to be in Mr. Bosch's estate, and the US Supreme Court said no, he had a fiduciary duty, so he wasn't really able to control the beneficial enjoyment of this non-voting stock because his decisions had to be made based on the fiduciary duty. Well, the tax court, in an unfortunate decision called Powell, P-O-W-E-L-L, said Bosch does not apply when there's no non-family members in the partnership and it's not a full business. So in Powell, a agent under Mr. Powell's power of attorney, also known as his son-in-law, noticed that Mr. Powell was going to die within a few days and transferred a lot of assets into a LLC type structure and made it so that he and Mr. Powell would control if and when there would be a distribution, and they gave away the 99%, took the discount. Powell died, and the tax court said Mr. Powell, in conjunction with his son-in-law, was able to vote on how to control the 1% interest, and therefore the assets were in Mr. Powell's estate. Now, to my knowledge, the IRS has only applied this theory or this subsection in abusive situations. For example, in the Powell case, where this happened just 2 to 3 days, I believe, before Mr. Powell died. But the way to safeguard against this is to make it so that the client does not have any power to decide if and when there will be a liquidation or distribution from the entity. So what we commonly do is our LLC operating agreement will say, Alan, the client, will own 0.9% as the voting member. He'll control what the investments are. He'll pay the bills for the company, but he will not have the power to decide if and when there will be a liquidation or distribution from the company. That will require a decision from the 0.1% special voting member, who will usually be not a close family member, not anyone that I have named as an agent in my powers of attorney because I'm allegedly in control of them, but it might be my sister-in-law who doesn't even like me. So my sister-in-law, as trustee of a trust for our grandchildren, has that decision-making ability. If you give that to her from day one, then you should not have a 2036A2 issue. If you give it to her after day one, then you have to give her 2 or 3 years before the donor dies. So that is the Powell decision. Now, another exception to both 2036A1 and 2036A2 is if the transfer of the assets, the transfer of that 99% interest, is a bona fide sale for good and valuable consideration. And there is an exception from the, I believe it's the Beauregard case and other cases where there was a really good business reason to set up the LLC. For example, I'm getting dementia, which everybody who is watching this clearly knows that's the case. And my family would like to protect the assets, and I'm not willing to give up control. So they convinced me, put it in this LLC, and we'll make your your wife's sister, the liquidation distribution person, so that we're protecting you. If you get dementia, you won't mess things up, and we'll make your daughter the co-general partner. So then there's a business reason for it, and as a result, 2036A2 shouldn't apply, even if I have a vote on when there should be a liquidation or distribution. So I'm just hitting the high points here as a review and some practical discussion for those of you who have the expertise in the estate tax planning area, and at the same time explaining how some of these practical things work in the real world. Okay, some more checklist items just on page 38 that we commonly see when we review estate plans. And one is that just trust. So typical revocable trust system, spouse one owns half the assets in a revocable trust. Spouse two owns half the assets in a revocable trust. When spouse one dies, only half the assets lock up. Spouse two may lose the other half. When spouse one dies, you get a new income tax basis equal to fair market value on the half of the assets of the first dying spouse, but not on the assets of the surviving spouse. Well, the just trust gets you everything locked up. You could fully fund the credit shelter amount, and you can get a full step up on all assets on the first death. So if my wife and I only have $6 million each, but we have high income, and one of us dies, we could lock up the whole 12 million and use that whole exemption amount of the first dying spouse. Now, if you're in Florida under Section D, you're a lawyer or CPA in Florida, remember the 10% cap. So we're always moving rental properties and investment properties and vacation homes into LLCs. Before you do that, check to make sure that they'll still be insured under the LLC, because a lot of insurance carriers and umbrella carriers don't like LLCs, and they won't cover property under LLCs. But the second consideration, which is really important this year and last year, is in the Florida property appraiser rules under our Constitution, they can't raise the tax assessed value that applies for most property taxes by more than 10% a year. So if you had a condo on the beach that was being taxed at $1 million in 2019, and now it's valued at $2 million. So they're not going to be able to tax it at $2 million right now. They'll be able to tax it at, for 2020, they'll be able to tax it at $1,100,000, and for 2021, they'll be able to tax it no more than $1,210,000, and for 2022, they'll only be able to tax it at 110% of $1,210,000. But if you transfer a commercial property from one spouse to the other, it becomes uncapped. Or if you transfer more than 50% ownership of an LLC that owns one of these properties, whether commercial or residential, it becomes uncapped. So we have to be careful about these situations. I have at page 41 what we call the smart estate planning considerations for, questions. Do you have special items that you want to go to a certain person? I had a really nice conversation with a client yesterday And at the end of the conversation, it was a fairly young couple. And at the end of the conversation, I said, any particular uh, physical assets that we should address? And the husband said, oh yeah, I've got my baseball cards. And I really want my baseball cards to go to my brother if we don't have children. And I said, okay, well, how much are your baseball cards worth? He said, $300,000. And I said, I'm glad I asked. If I hadn't asked, we wouldn't have known that. And then I said, and where are your baseball cards? They're in a safe in the house. Are they covered under your insurance policy? No, we can't get coverage. Well, why aren't they in a safe deposit box? And he said, they're not in a safe deposit box because they're like 20 shoe boxes of baseball cards. And I said, okay, but let's use the 80-20 rule and tell me this. How many cards would it take to be worth $240,000? And he said, this many. And I said, that will fit in a safe deposit box. So just a couple of words to the wise. I have had clients where when they were on vacation, professional criminals went into their home and drilled their safes and got their stuff. So if they're telling me about their stuff and what they've got in that safe at home, I'm going to recommend a safe deposit box. So there's a lot of questions here. Some of the questions have to do with philosophy, but some of the questions have to do with, if you die, will there be enough cash so everybody can do what they want to do, or is the bank going to call in all the loans? And I've dealt with situations where clients die and the bank goes, well, it was okay while Floyd was alive, but we have three concerns. Number one, Floyd's not running the business. Number two, there's an estate tax coming. And number three, we're a bank and we're not in the business of taking risks. We're only in the business of getting interest. So there's, not using a thorough checklist. And this checklist is a fairly good one from 2016, when I thought I was much smarter then than I think I am now, is the way the world works. What about buy-sell agreements? Those are widely forgotten about and then terribly written because nobody has time to think through all the contingencies. And the surviving spouse just is in so much pain because they don't know what to do with this co-ownership. Are they being taken advantage of? Are they taking advantage of somebody else? Would the first dying spouse have wanted to give it away? Or would the first dying spouse have wanted to get a lot for it? If you don't at least leave some guidance, if you're not going to have a buy-sell agreement, at least let the spouse know who they can look to for guidance on the buy-sell agreement. These things just really need to be thought through. And the other thing, if you've seen some of my presentations, I bring up this book. Marcia bought it for me for my birthday. I'm not sure how she chose it. It's called You Are Not So Smart. And everyone should read this book. It's a very witty book. It's written by a very experienced person who went back and got a psychology degree in the UK about 15 years ago, David McRaney. And it just points out how many blind spots we all have and how we don't think we're taking risk and we're taking a lot of risk. And our opinions we think are all logical, and they usually have nothing to do with logic. And as you learn when you get involved in litigation, people's memories will change dramatically based upon the results they're looking for. So you've just got to be careful when you're planning somebody's estate to try to spot these situations and just help nudge them along, to the right place, the right decision. One of the things we do as lawyers in risk management is, if a client is making controversial decisions, that's a polite way of saying terrible decisions, you've got to write a letter for the file and say, I told you not to buy the raccoon farm, and I don't think you're going to be able to sell raccoon tails that people will put on their rear view mirrors, and the aardvark zoo is a bad idea too. I don't think you're ever going to be able to teach those aardvarks to sing. So I'm going along with it, but I've strongly advised you against it. And let's go out to dinner with 3 psychoanalysts and see what we can do to help those aardvarks learn how to sing. So, sometimes we are able, if you're a lawyer or an accountant or another advisor, and a client sits down with you and they open up and they tell you what's going on, and like the Woody Allen story, the guy goes to the psychiatrist and says, I've got a problem. The psychiatrist says, what is it? He goes, well, my brother thinks he's a chicken. And the psychiatrist says, well, have you told him he's not a chicken? And Woody Allen says, no. And the psychiatrist says, why not? And Woody Allen says, because I need the eggs. So, there's just people out there who haven't got a clue of what's going on, or they need a polite nudge. We used to be able to hug them before COVID and the world of harassment. Now we can't hug them. We could just give them mental hugs or something like that, and try to help people. And to me, that's a big part of being an estate planner and being an advisor, that a lot of people just don't think about. It's not on the checklist. Now, don't put on your checklist for agenda with client, solve terrible neurosis and determine whether client is crazy. You don't need that on the checklist because usually it is the case. Then you have the agenda for the conference. So I hope you have an agenda, and I agree. Marty Shinkman gave a talk for us one Saturday and said, I don't have an agenda. I don't want an agenda. I want to listen to the client and I want to do what's right. But maybe it's not a bad idea to have a checklist to review at the end of the meeting. So sometimes at the end of the meeting, I pull out the agenda and I say, this is the agenda I was going to follow, but we went so well, we didn't need it. But let's just see what I'm missing. So it's a good idea to have a checklist, and then to have a checklist for your staff. So then when I sit down with the paralegal after the meeting and I tell the paralegal the whole story, if it's a 2-hour meeting, I talk for 15, 18 minutes, everything, I regurgitate everything as much as I can remember. And then things occur to me during the conversation, and the paralegal is also in the conversation. It's an active conversation. And then the paralegal says, well, let's go through the questionnaire that you're supposed to use, that you never use, and see what we missed. So not being thorough, not having a checklist would be another tragedy that causes tragedies. So hopefully, if you're in the business of doing this, you probably already have a questionnaire, but I'm glad to share my questionnaire. Bringing us to the 4th polling question, and physical freedom for those CPAs who are watching this presentation, not because you love me or want the information, but because you want the credit. So here it is, and I'm sure that there's no one here with that intent, but here it is. Under the reciprocal trust doctrine, A, if each spouse forms a trust to benefit the other, they may both be subject to estate tax. B, there are court decisions, including the U.S. v. Grace, a U.S. Supreme Court decision that permits this, but use extreme caution. And I personally believe that because of the way the creditor law works in many states, even the U.S. Supreme Court decision of U.S. v. Grace may not be correct. C, it is safest not to have reciprocal trusts. And D, which is the grade I got in high school chemistry, all of the above. And the correct answer, with 5 minutes remaining in this talk, is D, all of the above. So if you're getting CPA credit, you've now answered 3 of the 4 polling questions. You're good. I will do a 4th polling question at the end, just in case you missed one of them because you dozed off or you were taking notes so fervently during my presentation. So What should I cover next? The next thing I would like to cover is just a short checklist of estate tax planning topics. By the way, we have found that most of our viewers are asleep by now. No, most of our viewers are very interested in the federal estate tax. So here on page 67, some estate tax strategies. Number one, let your children set up a business that competes with yours. Or instead of you setting up the next locations, let your children set up new businesses that would be the locations. They could pay you a reasonable consulting fee. Get the growth of the business out of your estate. And if you want to know how to do that or not do that, there's a court case for BOSS, B-O-S-S, trucking, Trucking, and the business opportunity doctrine. Number two, use your annual gifting, $16,000 a year per child. It worked for Mr. Crummy in the Crummy tax court case, and it will work for you. Number three, put life insurance trust in irrevocable life insurance trust. Put life insurance in irrevocable life insurance trust. Do that more than 3 years before you die if you already own the policy. If you want the cash value back, then you can still use a life insurance trust and use split dollar. But under the recent Levine case, if you have a split dollar agreement and it says that the parties can amend it, then you need to amend that agreement to say that only the life insurance trust can amend it. If you want to know why, you can email me and just put Levine, L-E-V-I-N-E, in the RE line, and I will answer you. Number five, use those defective grantor trusts on everything. So a client recently came to me and about 60% of his net worth is in irrevocable trust from past planning. I'm like, that's great. What about the 40% that's worth $80 million? What are you doing with that? Well, I may give it to charity. Well, guess what? As you get older, your kids are going to talk you out of giving it to charity. So let's go ahead, put it in an LLC, take a discount, do an installment sale, get a note back at 2.25% interest, let the excess growth grow in these trusts that you've already set up. Oops, the trust has problems. Let's fix the trust. Okay, discount everything, freeze everything. The only possible example would be your pets. You can't freeze your pets or other animals. That's illegal. Or loved ones, or your IRA. You might even put your IRA all in bonds and put your equities in an LLC and freeze them. Okay, so my time, how am I doing on time, Kelsey? Kelsey's got the hook out, so I can just go to page 70, the final polling question, and then in 4 or 5 weeks, we'll do a part 2 of this, and I'll explain what I said in part 1. So the final polling question, and I apologize that I'm a little bit late here. It's at no charge to you. The advantages of a SLAT include no, not subject to estate tax, creditor proof, can benefit the spouse and descendants, and all of the above. And the answer is D, all of the above. So thank you very much for attending this presentation. We welcome your questions, comments, suggestions, gifts, and small animals. Have a fantastic rest of your Saturday, and thank you to CPA Academy for providing credit to my friends who are CPAs. Thank you, Mr. Dummy. Thank you, so. And thanks to Kelsey and Brittany, my technical support, and to my parents for raising me, my grandparents for having my parents, and the state of Texas and New Jersey. Thank you.